Major breaking news out of the United States Supreme Court in Washington, D.C. The lawyers for Zackey Rahimi have filed a powerful, compelling argument against the criminal statute 18 U.S.C. 922 G8, which is the question presented, whether or not that is constitutional under the Second Amendment. And Rahimi's attorneys have actually made some additional creative arguments that we're going to talk about in just 1 minute. A lot to talk about. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the detailed account of how the anti-gunners intend to take away our guns step by step. I lay it all out so you know what they're trying to do so you can help stop it. All right, major news, U.S. Supreme Court. The lawyers for Zackey Rahimi in this very important Second Amendment right to keep and bear arms case have filed their merits brief on behalf of Mr. Rahimi, and it is a powerful brief. It makes all the major arguments, and then some additional ones we'll get to in 1 second. So I have to congratulate the lawyers. There's several lawyers on this brief. The lead lawyer is Matthew Wright, who's with the Office of Federal Public Defenders down there in North District of Texas in Amarillo, and also his staff that worked alongside him, his colleagues did a great job. And also, it looks like they have a special counsel here, Brandon Beck, a professor at Texas Tech University School of Law. So to Matthew Wright and to Brandon Beck and to the team alongside them, great job on this brief. I think it did everything it needed to do and then some, and we're going to explain why in just a second. So for the purposes of this video, what I'm going to do is going to hit like 6 or 7 quick highlights. We'll talk more about the brief and the arguments as the Rahimi case moves forward. Keep in mind that the government has a reply brief coming up in a few weeks, and all the amicus briefs in support of Mr. Rahimi are due, I believe, on October 4th, in about a week from right now. We'll cover those when they come in. But for now, I want to hit the highlights of this brief. The number one argument I thought that is a killer argument in support of Mr. Rahimi and against 18 U.S.C. 922 G8, powerful argument, is they did a great job in their brief, specifically, and I'll put a link to the brief down below, pages 12 through about 15. They specifically point out that under the Bruin methodology, and just to remind you, the way it works, of course, is once the text of the Second Amendment is implicated, as that text is defined by the U.S. Supreme Court, the burden then shifts to the government to come forth with historical analog laws that are well representative of sort of the modern, or I should say the historical tradition of firearms regulation in the United States. Here it is no doubt because that 922 G8 is preventing Mr. Rahimi from having firearms, because once you're subject to a civil restraining order, as defined by the statute, you can no longer even possess firearms. And that is true, by the way, even if your ex-girlfriend who did this to you, let's say in Boston, gets a restraining order against you in Boston, and you happen to live in Phoenix, guess what? Believe it or not, that means you can't have a gun in Phoenix. And that is a powerful practical point that Mr. Rahimi's lawyers made about sort of the absurdity of the situation, that a civil restraining order with very fuzzy due process protections, if really any, can have that kind of draconian effect on a person's life. But anyway, let me continue on. So once the text of the Second Amendment is implicated, the burden shifts to the government to come forth with historical analog laws. And I think one of the most powerful arguments that the lawyers for Rahimi made here is that at the time of the founding, it was indeed a social problem that men would sometimes batter or engage in abusive practices toward their wives, and this was not socially acceptable. In other words, the history in this brief is quite detailed about how, yes, men misbehave toward women, husbands misbehave toward wives, and the founding fathers frowned upon this. In fact, in this brief put together by Mr. Rahimi's lawyers, they talk about how historians have said there are hundreds of cases where men were jailed for spousal abuse in every part of the country. That's on page 15 of this brief. Then he also goes on to say, or the lawyers go on to make a powerful argument that say that surety law, sureties of the peace, that says that wives were allowed to get sureties, which is like a peace bond sort of thing. In other words, if the husband was threatening the wife could go out and get a surety against the husband, making him post a bond so that if he misbehaved, he would lose that money and so on. So again, very powerful evidence here that at the time of the founding, there was concerns about women being abused by men. Now, the reason why that is legally important, is the lawyers here point out that in the Bruin case, This is essentially what they said in Bruin. The Supreme Court said this in Bruin. If earlier generations addressed a longstanding social problem, but did so through materially different means than gun control, then that is a powerful bit of historical evidence that the government cannot meet their burden of showing a historical tradition of gun control dealing with a particular problem. So I think what Rahimi's lawyers are doing here is to say, look, at the time of the founding, it was clear that people were worried about women getting beat or battered or assaulted by men, and they were concerned about wives getting beat and battered and assaulted by husbands. And we know that's why a lot of them were put in prison. That's why they were surety options. That's why there was also social ostracization here. Remember, it was a very religious community at the time of the founding. We were founded right initially by the Puritans at Plymouth Rock. These were people that were very religious, and treating people poorly was not really a Christian-like thing. Nevertheless, the lawyers here make a powerful case that this was a social concern, and the key is that the remedies, the steps that the founding fathers took to address this concern about spousal abuse and the like was not to engage in a form of gun control law or to disarm the men that were doing this. There were other means by which they were punished or prevented from doing so, but not through gun control law. And given the language that I just read from Bruin that appears in this brief as well, that is very powerful evidence that a civil restraining order is just not sufficient that a civil restraining order is not a sufficient basis to disarm someone just by virtue of its existence. But by the way, so I think the historical argument here in and of itself is very powerful. Beyond that, there's also a very practical argument that I thought the lawyers made that I was not really familiar with, and they really brought it to my attention. I give them great credit for this. And they point out that if you are a police officer working for the state, the feds, or whatever, and you are subject to a restraining order that would otherwise implicate 922G8, you can still carry your gun as part of your job. So they make a great argument here that says, well, if this is so important to disarm and keep these individuals away from guns, then why is it that Congress said, well, of course, if you work for the government, you need to carry a gun for your government, you can still carry a gun as part of your job. And I do think that shows a little bit of hypocrisy here, which, may not have legal significance, but I do think it sort of speaks to the framing of the issue. And I also think, on a related note, that the lawyers for Rahimi did a wonderful job in setting forth what I call kind of the facts of life approach here. They really point out that these restraining orders are in many respects basically rubber stamped. They're skewed one side. A lot of these are engaged, entered into against indigent people that really don't have maybe the financial or the intellectual wherewithal to really respond to a state lawyer trying to get them to enter into these things. And really that disparity in bargaining power and so on, power really makes, these restraining orders very kind of sketchy in many respects. And as you know from the United States Supreme Court case of Caetano, the one thing that maybe this brief could have made a little clearer was in the U.S. Supreme Court case of Caetano, Justice Alito in his concurrence points out that Miss Caetano's boyfriend and Caetano repeatedly breached and violated the restraining order. So again, this piece of paper, this restraining order, is simply not going to have any effect on criminals that want to engage in violence against someone else, because as we know from Cesare Beccaria in the 18th century, who we've talked about a lot before, that Italian Enlightenment criminologist that both Thomas Jefferson and John Adams really liked and looked to when they framed the Second Amendment. As you know, if people are willing to engage in murder, rape, and robbery and these terrible crimes, if they're willing to break those human laws, they certainly have no concern about breaking gun control laws, which are not nearly as serious. But let us continue on. So the next interesting argument, again, just to remember, once the text is implicated, and the text is clearly implicated here because Mr. Rahimi, as an American citizen, he's part of the people. Thus, when it says the right of the people to keep and bear arms, Mr. Rahimi's one of the people, obviously, as an American citizen, and he's being denied not just his right to bear arms, which means to carry guns in public, but also his right to keep guns in his home, in his bedroom for self-defense. So obviously, he's implicating the text of the Second Amendment that shifts the burden to government. So really, this Rahimi case is going going to be all about the historical analogs, if any, that the Supreme Court concludes either show a historical tradition of regulating the types of people who Mr. Rahimi is, or otherwise do not. So it's really going to turn on history. The good news is the burden of proof is on the government to show historical analogs, and they haven't done a great job here. Mr. Rahimi's lawyers really hammered home the different kind of historical analogs that the government set forth and really distinguished them in a very powerful way. For example, the Department of Justice has, tried to set forth these English laws, and they did a good job here in the brief saying, hey, we're the United States of America. We threw out the British. We threw out the English. So to bring English laws here to the United States that we specifically rejected, because keep in mind the English Declaration of Rights from 1689 dealt with only giving guns to Protestants. We in the United States gave guns to all of the people. That's why it's the right of the people as opposed to the right of Protestants, is because we rejected a lot of limitations on gun rights that you saw in England. And I thought Mr. Rahimi's lawyers did a good job, making that point, that our right to keep arms in the United States is broader than that in England at any point in time. So English precedents really don't do the government any favors here. The next thing to keep in mind is they did a really good job of pointing out that the government had previously relied on bigoted laws. These were laws that basically said you could take guns away from the freed slave, against slaves, freed blacks, Indians and Native Americans and Tories and whatnot. And basically they make the argument here, and I think it's right, that you can't use historical analog laws that disarm Native Americans, Indians, to justify taking guns away from Americans, because Indians and Native Americans were not part of the people because they were really considered foreigners. It'd be like saying, hey, there's a law in Iran against ISIS or whatnot, but that's irrelevant to what American citizens have or do not have as rights, as to how you treat foreign invaders or foreign powers or foreign citizens. It's a totally different animal. So on a related note, again, they also talk about the Tories, and I thought this was very interesting. They came across, and these are Rahimi's lawyers, came across an excellent quote from Thomas Jefferson, because as you remember, at the time of the founding, there was a Revolutionary War. You had the Patriots fighting against the Tories. The Tories were the Americans that decided to side with and help and or fight with the British in the American Revolution. And this is a great quote that they found from Thomas Jefferson, explaining that, yeah, you could certainly disarm enemy combatants such as the Tories because they were the enemies in a time of war. Again, that is a much different scenario and situation than taking guns away from an American citizen in a time of peace when that American citizen is being accused of something. That is a much different animal than taking guns away from someone that you're at war with. So specifically, the quote from Thomas Jefferson here on page 24 of the Rahimi brief says, quote, "It cannot be denied that the state of war strictly permits a nation to seize the property of its enemies found within its own limits or taken in war." Period, close quote. That was a letter from Thomas Jefferson to George Hammond, I believe. And again, you can find that on page 24. Again, very powerful evidence that the historical analogs of disarming the Tories is a wartime issue and has nothing to do with the ability to take guns away from me or Mr. Rahimi or you as American citizens under the Second Amendment. Just three final points. I want to say that they did a great job. They also point out that the proposed constitutional amendments that were never adopted, those have already been said by the U.S. Supreme Court to be of dubious value historically, because again, proposed constitutional amendments that were never adopted for a reason. So what can that tell us about the Second Amendment that was actually adopted? So they do a good job pointing out that indeed the proposed constitutional amendments suggested by the Department of Justice as somehow speaking to a historical tradition of firearms regulation or whatnot. Clearly those are dubious. That's not me saying it. That's not even Mr. Rahimi's lawyer saying it. That's the U.S. Supreme Court has repeatedly said that proposals to the Constitution that are never enacted are of dubious historical value. And let us continue on. The last point I want to make here is that, and this is very powerful, we've talked about this on this channel before, on page 50 of their brief, Mr. Rahimi's lawyers point out that any suggestions that the Department of Justice and the government needs to have 18 U.S.C. 922 G8 to be enforced to protect public safety is simply not true. And the best evidence of this, as we've talked about on this channel before, is it's basically never used. As you know, we talked about there are 5-year periods in the past where you have something on the order of magnitude of 27,000 convictions of individuals in the United States who have violated 18 U.S.C. 922 G1, which is that you cannot be a felon and in possession of firearm. In contrast, the statute that we're dealing with here that was pushed upon the Supreme Court by Attorney General Merrick Garland, 18 U.S.C. 922 G8, as Mr. Rahimi's lawyers point out, between the year of our Lord 2018 and the year of our Lord 2022, that 5-year period, how many people were convicted and sentenced? 167. 167 people in the United States were convicted in that 5-year window of 2018 to 2022. That's less than one person per state per year if you do the math. So why did Merrick Garland race this case to the Supreme Court? It has nothing to do with public safety. It has nothing to do with Mr. Rahimi. It has everything to do with trying to undercut the Supreme Court, the Second Amendment, and the methodology of interpreting the Second Amendment as set forth in Nysurpa versus Bruin. This is what this case is about. The last thing I should mention, I forgot this one point, very powerful argument, is that Mr. Rahimi's lawyers have essentially raised a form of a Commerce Clause argument or an argument about the authority of the government to enact gun control laws generally. We'll talk a lot more about this down the road. This is going to require an independent standalone video, but basically they've made an argument here that says, regardless of the Second Amendment, the fact is that Congress does not have the constitutional authority under Article 1 of the United States Constitution to enact these kinds of gun control laws involving a firearm that is already owned by a particular person in a home. So this is really a type of Commerce Clause type argument to say that there's simply no authority. Keep in mind that the federal government is not the state government, and state governments have what are known as police powers, which is like a generalized power to do good for its people. But that is not the case with the federal government of the United States, because the United States government is a government of what's known as enumerated powers. And if those powers are not enumerated in Section 1 of, or I should say in Article 1 of the U.S. Constitution, they're not supposed to act. The broadest approach, of course, is they try to use the quote-unquote Commerce Clause to define and cover everything under the sun. But the Supreme Court in the last couple of decades has been cutting back on congressional power to some degree, not enough, but to some degree. One wonders whether or not the Supreme Court might even take Mr. Rahimi's lawyer's suggestion up here and actually rule against the government in favor of Mr. Rahimi on Commerce Clause grounds and never even get to the Second Amendment. But we'll talk about that in a separate video down the road. But for now, I just want to let you know that I think Mr. Rahimi's lawyers did a very good job. Powerful briefs. I'll put a link to it down below, and we'll see how this plays out when the amicus briefs come in for Mr. Rahimi and the government's reply briefs comes in. And then, of course, I think in November, we're going to see an oral argument, which we, of course, will cover. All right, folks, hope you learned a little bit something here. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.